Hello. My name is Jones, and today we're looking at admission of a psychiatry patient. So it's important to know that there are different types of admission in psychiatry, and we're going to appreciate each and every one of those admission types that we see in psychiatry. So, in psychiatry, patients are admitted for care when they become a danger to themselves or others. There are three types of admission that govern admission to a psychiatry or other medical facilities. So, the main types of psychiatry admission that we have are three, but we are going to see also other different categories of full admission that we see in psychiatry. Okay, so it is to be remembered that whilst admitting a patient to protect the general public, care must also be taken to avoid infringing upon the patient's rights as a person and also as a patient with a mental disorder. So, types of admission. There are several types of admission. So, we have voluntary admission, emergency admission, involuntary admission or compulsory. Okay, so involuntary is also known as compulsory. Then we have got also court adjudication or adjudication types of admission or admission through advice by the medical board. Okay, so voluntary admission, as the name suggests, voluntary admission, this is where a patient is willingly, okay, the patient is willingly to be admitted and knows that he or she has a problem. And the medical officer in charge of the mental hospital sees that the patient is or really needs admission. So there is voluntary bringing of the patient for admission so that the patient cannot be a danger to self or cannot be to others. And then the patient is evaluated to see that there is need for admission. So the Mental Health Service Bill of 2006 states that patients aged 18 years and above must be encouraged to opt for voluntary admission into a psychiatric institution, facility, or ward. Okay, so patients with mental health problems may seek help from any health institution, including primary health care clinics, as first contact before being transferred to a psychiatric facility. If any patient is admitted to a psychiatric facility as a voluntary patient, the person in charge of the hospital or ward must notify the patient's parents, guardians, or relatives as soon as possible. In the absence of relatives, community leaders from the same locality must be notified. This is to help with the continuum of care because patient is not in the right state of mind to consent to certain things that need to be done at the medical service point of view. So where a patient is already admitted to a mental health facility as a voluntary patient but wishes to discharge himself contrary to the considered opinion of the person in charge, the patient may be held at the institution or ward as an involuntary admission upon recommendation of attending mental health practitioner or psychiatrist. A patient who comes to the hospital, okay, voluntarily or is brought by the relatives voluntarily so that they are helped. At some point, they might seek to be discharged before the final evaluation to show that they are fit to be reintegrated within society. So at this point, it is the evaluation by the psychiatrist, okay, that will determine whether patient is to be discharged or not. If patient should not be discharged, then the patient can be held an admission against their will. So this now becomes an involuntary admission. So a mental health practitioner should physically and mentally examine any voluntary patient within 24 hours of admission to a mental health facility. Then we have from voluntary admission, then we have emergency admission. A family member, friends, or community health worker, or any responsible citizen may request orally or in writing that health institution admit a suspected mentally disordered person as an emergency admission under following conditions. So the conditions may include: 1, if a person in the community begins to act in a manner inconsistent with the norms of society because of suspected mental illness. Okay, the other recommendation can come if a person in the community is believed to be mentally ill and because of mental illness lacks proper care in terms of food, clothing, and shelter, or is neglected or cruelly treated within the community. Then someone from the community may recommend for admission of this patient. The other reason that community member may recommend admission for a patient with mental illness is that if any person is believed to be suffering from mental disorder, that person becomes dangerous to himself and others or property around, then for the safety of the patient, it is important that the community member from within that area where this patient starts acting against some norms of society recommends the admission of such a patient. Okay, so then we have involuntary or compulsory admission. This is where the patient is not willing to be admitted and does not accept treatment or is unable to give consent for treatment, but he or she has a problem, illness, or a potential abscondee. So involuntary is the opposite of voluntary. So we started with voluntary admission, then we went to emergency admission, then we are now looking at involuntary or compulsory admission. So involuntary, here patient is not willing to be admitted, or accept treatment, but is unable to give consent for treatment because of his mental well-being. So this is a potential abscondee. So you might need to admit this patient and confine them into the ward. A detention order will permit the compulsory emergency admission under the legislation or law in place within that country. So according to human rights, you are not supposed to force the patient to be admitted or to force the patient to take medication. Hence, you get detention orders, a form which is signed by the magistrate, and this will allow medical personnel to enforce the admission and administer medication to help such a client. Without a detention order, you can be sued. Detention orders are obtained from the police station or from the magistrate court. So they may have this mental health problem, but you need to have a detention order in order for these patients to be admitted or for the patients to be legally admitted. So the Mental Health Service Bill of 2006 stipulates that involuntary admission to be initiated by a family member or a friend or community health worker who takes a person suspected of suffering from mental illness to the nearest health center, where such a person is examined by an approved health worker, who then certifies in writing that the person required to be detained suffers from mental illness. An approved health worker, if certified, then that 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 person is mentally disordered and is dangerous to himself and others, they shall refer such a person to a psychiatric facility or ward within 5 days of such certification, where the person so certified is to be admitted within that health facility. Upon receipt of the person in charge of the said psychiatric facility shall then ensure that the patient is examined physically and mentally. The patient must not be admitted to or detained in a psychiatry institution unless the person in charge of psychiatry institution is of the opinion that no other care of a less restrictive kind is appropriate and reasonably available to the patient. Okay, so apart from that, where the patient is of opinion that his admission or continued detention is unjustified, he may appeal to a mental health review board for review of his decision. This is where such a patient has such capacity. So they may appeal to the mental health review board to against the admission. So the review must be carried out within 14 days of the receipt of the application. Any patient involuntarily admitted shall not be detained for more than 14 days without review by a mental health practitioner. Admission under medical board. So this is the fourth type. Okay, we started with voluntary, emergence, involuntary or compulsory admission. Then we have admission under medical board. So this is when the employers writes a letter to the hospital requesting the medical officers, who in turn consult the psychiatrists where applicable, to examine the patient thoroughly and come up with a report to say whether a person can continue working or be retired on medical grounds. So this will state admission under medical board. So admission by court adjudication. So admission under medical board, and then we also have admission by court adjudication. So in admission by court adjudication, the client is admitted into a psychiatric forensic unit by the court's decision, whilst the case is being reviewed by the courts of law. In the psychiatry hospital courts, requests for assessment, treatment, and psychiatrists are required to submit periodical reports to the court. So here, in admission by court adjudication, mostly it will come when someone with a suspected mental illness has committed a crime. Now they want to ascertain the mental health status of such a client. So in these reports, the following examinations should be included: previous psychiatric history, past medical, surgical, obstetric, and early childhood or adolescent developmental history, social histories, alcohol and drug history, family history of any mental illnesses or any offenses within the family, marital status, education and employment record, prognosis of a disorder and outcome if necessary. Okay, so the important issues on which opinion may be required in the psychiatric report are the mental state at time of interview and of the alleged offense. It must be established whether the person was mentally ill at that time that the offense was committed. So competence to attend the competence of the patient was also assessed to attend court and also make a defense. If a person has cognitive challenges, they may not be competent to attend to court or make a defense. So to do with criminal responsibilities, does the patient really understand the difference between pleading guilty and not guilty? Does the patient understand the nature of the charge? So, all this constitutes the cognitive competence of the patient. So, let us now look at the admission procedure. The admission procedure consists of history taking, mental state examination, physical examination, investigation, and a diagnosis is arrived at. The clinician or psychiatrist will come up with the psychiatric diagnosis, after which the patient is commenced on appropriate medication to stabilize him or her and reduce symptoms. Okay, so you as a nurse, you have to conduct your own assessment, which would include demographic details, chief complaints, okay, and various histories and mental state examination when you are examining a patient for that. So today we have been looking at a psychiatry admission, and within this lesson, we have learned that we have three main types of admission. We have voluntary admission, emergency admission, and involuntary admission. Then other types of admission, it can be by advice from the medical board, or it can be because of court adjudication. Okay, so from me, I'm saying thank you and keep studying.